How to file a lawsuit in Florida. As with most other states, filing a complaint is the first step to beginning a lawsuit in Florida. This is the document in which you lay out the allegations against the defendant and allege how you have been harmed. Keep in mind that you do not need to try and prove your allegations in the complaint. You are only alleging what happened. Of course, to ultimately prevail at trial, you will definitely need to offer evidence that supports the claims you initially make in your complaint. However, simply alleging that you have been harmed is not quite enough. You must allege a type of harm that Florida specifically recognizes as a recoverable claim for relief. For example, if you trip on the sidewalk, you cannot necessarily sue the city for your damages. The plaintiff will need to allege that the city or someone else was negligent in some manner. Perhaps the sidewalk was in a poor state of disrepair. In that case, they can likely allege that the city had a duty to keep the sidewalks in good condition. They failed to perform that duty, and as a direct result of that failure, the plaintiff was injured. Each specific aspect of a claim for relief, sometimes called a cause of action, is known as an element of a claim. If a plaintiff can prove each element of their claim, they should win their case. Similarly, if a plaintiff has been physically attacked by someone, they can probably bring a civil lawsuit for battery if they can allege that the person physically contacted them and they suffered harm as a result of that physical contact. The elements used above are general examples only. A plaintiff needs to research the individual elements of any and all claims they wish to bring against a defendant and make sure they properly allege facts that, if proven, will satisfy each element of their claim. The best place to research elements of specific claims is your local law library. Filing and serving the complaint and summons. Once the complaint has been drafted in the proper style and format, the plaintiff will need to file it at the appropriate courthouse and pay the applicable filing fee. If a plaintiff has limited financial means, they may be able to qualify for a fee waiver/deferral and can ask the court clerk for a fee waiver application. Once the complaint has been filed, it will need to be served on the defendant. In Florida, when you file your complaint, you also need to fill out a summons. The summons is the official legal notice that requires the defendant to appear and answer the charges in the complaint. The clerk should have a blank summons form available for you to fill out. Engaging in the discovery process. Once served, the defendant will have a certain amount of time to respond by filing an answer to the complaint. After an answer has been filed, both sides will engage in discovery, where they are required to disclose information to each other. These disclosures are made by each party, sending the other a request for production of documents wherein they ask for specific documents that are relevant to the case. Our Florida civil lawsuit package contains forms, samples, and instructions on how to send and respond to requests for production. Discovery often includes depositions of witnesses as well. Presenting your evidence in court. After discovery is completed, a hearing or trial will be set and both sides will present their case to a judge, jury, or private arbitrator. This includes submitting exhibits and interviewing witnesses. Once both sides are finished presenting their claims and defenses, the judge or jury will find in favor of one party or the other. How to file a lawsuit in Florida. To conclude, if you found this video informative by a show of thumbs, how many of you did all in favor? Thumbs up, let's hear it. Express your thoughts below. Thanks for watching.